Welcome everybody to this, our third seminar in the Intergenerational Feminist Dialogue series. That's hosted by the Saatchi Chair in Gender Politics at the Stellenbosch University and the Department of Sociology at the University of Victoria. I hope that everybody can hear me, that I'm coming through. And my name is Debbie Bonnen, and I'm going to be facilitating and moderating this seminar. Can I just ask those of you who have your mic on, if you wouldn't mind muting, because I think there's a bit of feedback. So this afternoon or today, we're going to be, the topic of the seminar is feminist legal gains and setbacks from the Zuma rape trial to the Koko judgment. And we've got a great set of panelists, and our panelists include, sorry, I'm just looking at my instructions. We have Sibongile Indashe from the Initiative for Strategic Litigation in Africa. And the panelists will talk in this order. I'll introduce each of them in more detail before they come to speak. Shireen Hassan from Carleton University. Kwezi Lomso Mbandizayo from Oxfam, South Africa. Furata Chengeta, Wits University, #RU Referencist, and Bronwyn Pise from the Women's Legal Center. And each of our panelists will give us some opening remarks for about 10 minutes. And then I will give them space to respond to what other panelists have said, and we will move on to Q&A, finishing off at 2 o'clock. And I'd really like to thank our panelists for giving up their time to contribute today, especially Shireen, who is not well at all. So we're going to start off. The first panelist is Sibongile, and she's the Executive Director and founder of the Initiative for Strategic Litigation in Africa. She studied law at the University of Western Cape and has worked in different capacities at the Legal Resources Center, the Constitutional Court, the Women's Legal Center, and the International Center for the Protection of Human Rights. At Interrights, she was the lead lawyer on equality in Africa, and her focus areas were litigating sexual rights and women's human rights. And this work included the first case on women's rights at the African Commission on Human and People's Rights, which was Al-Kia and others versus Egypt. She gained a bird's eye view on how the law and courts in particular can be used to advance the human rights of women and people whose rights are violated on the basis of sexual orientation, gender identity, and expression on the continent. Sibongile's work is driven by developing jurisprudence in gender and sexuality before the African human rights system and domestic courts. Through her work, she's nurturing a pool of feminist litigators with expertise on gender and sexuality, in addition to the legal empowerment of social movements to make decisions about litigation. She writes, teaches, designs, and implements capacity strengthening programs on strategic litigation for lawyers and social movements. And I will hand over to Sibongile. Thank you. Hi, Sibongile, are you there? You muted. If you wouldn't mind.
I am here. Can you hear me?
We can hear you now. We can't see you. I don't know if you're able to put your camera on.
Yes, I am.
Hello. Sibongile? Okay, I think that Sibongile is having some issues, so perhaps we will come back to her, and that means that I'm going to then introduce Oroto Chingeta, who I hope I can call on you to come next. She is a writer, or they are a writer and doctoral students at the University of Witwatersrand. During her undergraduate studies, she became involved in gender advocacy and anti-rape activism, and her experiences as an activist moved her to explore Black women's experiences of sexual violence through her research. As a scholar, she's interested in people's narratives, in their emotional lives, and in holding space for their lived experiences. Over to you. And could I just ask everybody to check that they are muted? Thank you.
Thanks so much. Let me know if people can't hear me, because I'm just obviously speaking into a room by myself.
Yes, we can hear you and see you. Thank you very much.
Thanks everyone for joining. Also, please let me know if I go over time, because sometimes I do that. So thanks everyone for joining, and thank you, Simamkele and everyone who organized this for the invitation. I think when I was thinking about the topic for today, and the opening remarks and what I thought I could contribute to the conversation, I thought maybe the best way to go about that would be to speak about the different experiences I've had and the different locations that I've kind of moved through, so that everyone understands like where exactly I'm positioned and how I kind of see the topic. So the conversation topic today has a lot of focus on the law. And initially when I received the invitation, I wasn't sure if I would be an appropriate person to speak on this topic, because it is something that I have a complicated relationship with, right? So in thinking about the question, I decided to take up the invitation anyway to see where I could meet other feminists and kind of have I hope, really fruitful conversation about the different places that we can work on this issue together from. So the first thing that I wanted to speak about was just a history of like what I do and the projects I'm involved in. So when I was in undergrad, I found myself being interested in gender advocacy, and I was like a feminist identifying person. And through that, I was very involved in campus activism and campus advocacy around gender issues. And at the same time, I was becoming very interested in sexual violence. And because I was at Rhodes University specifically, I think that there was a history of activism around gender-based violence and sexual violence, stemming back to the 1 in 9 campaign, which I think predated me being at Rhodes by at least like 5 to 7 years. And so when I got to Rhodes as a student, I became kind of plugged in to the silent protest, the Gender Action Project, and different organizations within the institution that were speaking up against rape, which became my personal focus in my research later on. And I think that kind of introduction to, you know, university life and also like adult life was something that would mark the trajectory of my my career, but also my opinion on the different feminist legal gains and losses and that sort of area. So the first thing I think about when I'm thinking about like that introduction to feminist advocacy is how, for me to experience at Rhodes the silent protest as a way of advocating against rape and making visible a problem that was largely privatized and, because of shame and social stigma, invisibilized, right? In order for that to happen, one of the things that had to first occur was the rape trial against Jacob Zuma. And I think it's very important to think about how that action in opening a case, even though the outcome, as we know, was deplorable and really disappointing, it opened up the trajectory for a lot of different movements. It birthed something, even if it wasn't a feminist legal gain in the sense of like what actually happened with the case. A lot of advocacy was birthed from that, and people like me were eventually down the line introduced to activism as a result of that. So I think there's something to be said about different kinds of resistances, and a way I like to think about the importance of resistance in the feminist and legal spheres is that, you know, you can never tell what the impact will be, but it's always important to do it. So even though it wasn't necessarily like in the legal sense of feminist legal victory, I consider that the consequences of the rape trial against Jacob Zuma to be a catalyzing moment for a lot of activists, and in that way becomes a feminist, I don't know how to, like a feminist, like a milestone, or I don't know what the word is, but a really important moment in the trajectory of activism in the country. Moving on from that, in my advocacy during Rhodes, the time I was at Rhodes University, there was a series of protests around sexual violence known as Chapter 212, which was speaking to the right to safety and the right to safety from harm as enshrined in the Constitution. And then there was Are You Reference List, which was a response to the circulation of a list of alleged perpetrators of sexual violence on campus. And these two protests, having witnessed and been part of them, I think they also kind of orient how I come to this topic, because in one way, there was the one that was speaking to the Constitution, Chapter 212, which did not get the desired results, in the sense that it was largely ignored by the institution, and it did not have the effects that the activists who participated wanted to have. And for me, that's a broader thing about what it means to appeal to legal instruments and to critique them, right? And then several days later, you have Are You Reference List, which was a very different kind of protest, which was characterized very much as unlawful, right? And further criminalized through the expulsion of some of the activists who were involved. And for me, having experienced those two protests has complicated my idea of what a feminist legal gain is, because the one wherein we were speaking about the law and trying to agitate for change, it was really, really difficult. Whereas the one that was more confrontational really took off and had a lot of results, not in the sense, again, of necessarily changing things, but in other things that I think are important, like creating community and speaking to the problems and visibilizing also in a way that could not be ignored, the problems of sexual violence that we were facing on our campus. So just kind of wrapping that up, I think what these experiences have led me to kind of think about is really how the law, for me, is a site of extreme disillusionment, but how that disillusionment about the law is also a really powerful site of potential agitation, political education, and radicalization. And I'll leave it there for now.
Thank you very much. Thank you very much indeed. I'm going to then move on to Shireen Hassam and call on her to share her thoughts with us. Shireen is based at Carleton University for a 7-year term as the Canada 150 Research Chair in Gender and African Politics. She's a former professor of political studies at Wits, and she's written and edited several books, including No Shortcuts to Power, African Women in Politics and Policymaking, and Go Home or Die Here, Violence, Xenophobia, and the Reinvention of Difference in South Africa. For the book, Women's Organizations and Democracy in South Africa, Contesting Authority, won the Victoria Schack Award from the American Political Science Association, and her most recent book is the ANC Women's League. Shireen is a member of the steering committee for the Women's Living History Monument, which is developing the first museum of women's history in Africa, and she's also the first Black woman full professor of political science in South Africa. Over to you, Shireen.
Thank you, Debbie. Let's see how I can get through this without coughing too much or losing my train of thought. I think this is an intergenerational dialogue. I want to go back to past generations, not just the generation that is the one I represent, but also the generations that struggled for rights in South Africa and across the continent for hundreds of years, right? So the issue of women's sexual and reproductive rights can be traced back a very, very long, over a very long history. And, you know, I want to just look specifically at the 20th century, because that was so formative for South African, for the South African legal changes, but also because the processes of decolonization to the north of us were hugely instructive. People there wasn't the internet, but there were various modes of communication across anti-colonial struggles, and there were, and because South African activists were in exile in other parts of Africa, there were many shared lessons and attempts to kind of create a system that might obviate some of the worst pitfalls that other women in other places faced. So in fact, the struggle against sexual violence and sexual harassment can be clearly traced in the South African case to women's experiences in the workplace, where women were treated as always available for bosses, particularly for sex. And you see, and Debbie, you've done some work on unions, so you'll correct me if I'm wrong, but I wanted to bring that in because I want to make the argument that in the trying to struggle for those rights in the factories, on the factory floor, in various workplaces, in homes, right, where women were domestic workers and where they did not have the protection of unions, but were extremely vulnerable to abuse by employers. There was, in making those claims, women really had to create the understanding that to treat those as illegal, to treat those forms of violation as illegal, was the right thing to do, because for the most part they were seen to be not part of the remit of the law, but part of the private sphere. They were, either it was seen as, your husband's right to do this, or men's right in general. And so making something part of the public sphere and therefore part of a legal system that would criminalize it was in itself a struggle. It's not something we should take for granted. It's not something we should assume that people that was given to people. It was something struggled for from below, fought for from below, and imperfect. So I want to say that because I think that the issue about law and our engagements with the law, I think there's too often a tendency to think about the law as something that is finished, as something that is just there, it's on paper, and it's not the subject of struggle. But every part of the law has been subject to historical struggle and is subject to contemporary struggle, right? We give it, in the ways in which we give it meaning. The other point to make is that often the law that was put on the books was bad law. It was law that continued to inscribe women as not worthy human beings. So, much of the law, much of colonial law, it's not that they invisibilized women, it's that they included women as unequal, exploitable, rapeable subjects, right? So in the 20th century, you see women grappling with all of that, and in the 1980s, when the South African feminists were trying to think about the ways in which you might have a different kind of system in South Africa, we were learning from the women's legal mobilizations across the continent, especially in the Women in Law in Southern Africa, for example, an advocacy organization that was beginning to take up, based from Zimbabwe, beginning to take up unequal and exploitative laws. So what we have was not a perfect system, but I think there was some optimism in the early stage of democracy in South Africa, and that people felt that there was the political will to have something different. What became clear in the Jacob Zuma trial is that the ANC was not going to be an ally for that. That when push came to shove, they would protect They would protect their leaders over women, and that they would do that even over the most loyal and most committed members inside the ANC. That was the case. It was two cadres within the ANC up against each other, and it was very clear who was more important. And what was also very clear at that moment was that the ANC Women's League, which I have always written was never on the side of feminism, it was really proved that they were not on the side of feminism and not on the side of feminists. So we saw that rift that had been brewing, I would say, for decades. We saw that rift come to a boiling point in the Jacob Zuma trial. And I think that it was a tipping point and a turning point for South African activism, because it reminded us of something earlier generations, I think, knew, which is the law is never enough. Having a law is never enough. You have to have, and you can put a lot of energy into crafting the most perfect law and the most perfect institutions, but really what matters is collective action from below that is organized, that is mobilized, and that is constantly challenging the terms of power. Because law, in the end, a law seeks to stabilize power, and it seeks to stabilize the power of those who already have power in a way. So we're always having to be alert to that. We have to always be alert to the ways in which power is being reconfigured. I'll just conclude because I feel quite tired from speaking, but I just want to say that I think we have to, it's not the law or something else. I think we have to have both. We have to make sure that we are always working for the best law that we can put in place in order to protect all those people who cannot, who don't want to be left to the arbitrary power of civil society, which is very arbitrary in my view, and of the arbitrary power of family and a community. So we need to have the best law that is there, but we also have to be looking at how we organize and mobilize in everyday ways to challenge the stabilizations of patriarchal power.
Thank you. Thank you very much, Shireen. I think from both speakers, we've heard that the law is a site of struggle. For me, that's the theme that's come through from both speakers. And without struggle, we will not have, we will only be disillusioned, I think, in the law that is in place. And I'd now like to then introduce our third speaker, who is Kwezilomso Mbandazayo. She's a women's rights and gender justice She is the Women's Rights and Gender Justice Program Manager. She's a Black queer feminist thinker and activist. She holds life experiences and lessons from being in the world together with insights imparted by activists, Black feminist friends, teachers, scholars, and families. She's worked with organizations and collectives where there is a shared critique of an oppressive status quo, together with unrealistic dreaming practices for feminist utopia, such as the 1 in 9 campaign, the Forum for the Empowerment of Women, Johannesburg's People's Pride Movement, and the United Front. Her interests lie in and are driven by music and the words. Kwezilomso is consistently exploring the themes of organizing and movement building, navigating the nuances of power, sex, anger, love, and desire for Black women. Over to you. Thank you.
Good afternoon, everyone, and I hope I am both visible and audible. and thank you for the invitation to form part of this quite, I think, a difficult conversation, but an important and interesting one. Um, I mean, I come at this conversation not necessarily as a kind of legal scholar, because that's not who I am, but really as a person who is very interested in narratives and the narratives that we tell ourselves about who we want to be, about who we are, and about what we value just as a society at large. And so when I started thinking then about these two judgments or these two cases, I must admit to being heartbroken, but not surprised. Especially, right, if I think about, that the Xoxo judgment comes a good 2 decades post, and one would imagine, or one would hope, or one would think that there've been some radical shifts in the treatment of survivors of violence. In the processes as a whole, we see pretty much the same thing. And so for me, I wanted to touch points on a couple of these stories that I think become important in terms of how the law and legal systems, what's the word I want to use, re-entrench or kind of popularize. And the first for me, which really I heard in the Xoxo judgment, is this idea of a supremacy in a way of interpreting the law, and a supremacy just in kind of how we understand fairness, justice, and this idea that the bench can be and is very objective and can do only this much and no further, and the law is the law and this is what it is. When various scholars have told us, especially in the Xoxo judgment, and I'm hoping that some of my colleagues who know a bit more of the detail, that even in the kind of stricter interpretation of what is in the law books, it is impossible, like feminists have said, to divorce how we interpret with the dominant kind of patriarchal narratives. It is, Judge van der Merwe in the Zuma judgment kind of started with this whole, I have ignored everything around me, I have ignored context, and I've just, giving a judgment based only on the facts, and then went on a teaching spree on his ideas around morality, his ideas around truth, his ideas around, why would Fezeka do this and why would Fezeka say this, and this kind of embattled older man who made a mistake, and this confused younger woman. And so that was not devoid of a particular lens, and that lens which was very much anti the survivor in the case. Similarly for me in the Xoxo judgment, right, where the age of the perpetrator becomes, so it's like these are two people of the same age, and yet we all know that gendered power does not work like that. And so it's and what we then get told once we're trying to poke holes into these dominant stories is that's just what the law is, and don't fight the bench but fight the legislators. And I don't think that is it. That's I think that's disingenuous. And that kind of also takes me to the second story, right, which one cannot, what's the word? You can't run away from in these cases. And it's a term that Shireen used actually many, many years ago, and I don't know if she remembers when we were talking about the Zuma judgment, but it's a kind of complicated and complicating desire, right? Because now these are all cases where we have stories about, and we are having conversations about sex, about consent, about desire. And what it points to, again, is that we cannot divorce the kind of legal system or the legal interpretation and outlook from society, from how women are socialized into being sexual beings, vis-a-vis how men are sexualized into being are socialized into being sexual beings. We cannot divorce it to the kind of weight that gets placed on penetrative sex and understandings in terms of sexual debut that we are all taught, right? This is what sex is and this is what sex looks like. We can't now then just ignore all of this and say, well, there was tacit consent or there was consent because there was no express no before penetration. And again, for me, this is completely disingenuous when we all know what the scripts are for what sex is and what it should be and what it can look like and what virginity is and all of these conversations. And it goes to even, and I'm not going to call them murky waters, because I do think that the fact that the instruments that we have to deal with this kind of harm are incapable of encompassing the harm also looks like the fact that patriarchy then exploits this, right?
Yeah.
And so we will pretend like there's no, we will pretend like we do not understand consent. We will pretend like we don't understand body language. We will pretend like we do not understand movement and all of this. When all of us as sexual beings have this language and have this knowledge, have the knowledge of a difference between flirtation and force. But because the instrument doesn't give way to this nuance, then it allows for, you know, how could he have known? Of course, our lovers know when, you know, it is non-consensual. And for some reason, not for some reason, these are conversations that are a bit more difficult to have within the boundary of what the legal system looks like, but important because, of course, there's no way to say you want to assess harm and what should be done about this harm whilst not looking at the broader context and the broader nuance. Sorry, I had made notes, which is always very important to me because then I can always go off on other kinds of preaching tangents. I think that the last kind of point that I wanted to make in these remarks is that, well, for me, one of the bigger differences in the time was a more, so when the Xoko judgment comes out, I feel, and I haven't done, you know, research on this, so please do not beat me with the stick. But I feel like the country was at a different place as it relates to believing women and believing women the first time around, and narratives around victim blaming. And of course, that is because of, you know, continued struggles, continued. The you know, feminists, this did not just happen, that we now have an emergence of when women say that they've been violated, believe them the first time around. And some of the kind of contestations, even, you know, publicly opinion pieces regarding the Xoko judgment are showing that we have moved in this instance. The one thing that is now that is now I'm obsessing with as it relates to our we believe her moment is again the insufficient instrument that we have in the kind of criminal punishment system, as abolitionist scholars will call it, because we believe her is a kind of call to understand violence is structural, right? we're saying that a particular gender of people placed in, a race, a class in these ways is wholly rapeable. And the perpetrator is most likely, most often, this kind of group of people. So this has nothing to do with not nothing, but this has very little to do with our individual feelings towards each other. We believe it's about an understanding of the structural context and how violence is organizing the lives of all of us, men, women, gender non-conforming people. The problem for me then is that for me is quite a radical shift and a beautiful shift. Now we then need to be a bit more imaginative about structural solutions to a structural problem, because one cannot then take a kind of structured view of how violence happens and want to individualize it and think that we are going to get justice. So that for me is one of the things that I'm thinking through at the moment, that says, of course, then, in the criminal punishment system, it's one survivor, one accused, to try and find truth. But this trying to find truth is quite adversarial, etc. What are some of the options and thinking and widening of the scope of how do we understand this violence? How do we understand the harm? And how do we understand justice? And what are some of the other avenues, the other instruments we can use to think about, deal with? I'm also a fan of, it's not either or, but I would love to live in a place where we have more options, especially given that, and I'll definitely go here because I know that I'm out of time. I would definitely like to live in a place where more survivors come out about their experiences to different spots and different systems, because as it stands, we're not necessarily, it's the numbers of people who are reporting are far less than the numbers of people who are experiencing the said violence. And let me close it there.
Thanks. Time's up, but you were finishing off in a great way, so I didn't want to interrupt you. Thank you very much. I'm wanting to go back now and see if we can bring in. Sorry, I'm just looking through my notes here. Oops, all upside down. Yeah, Sibongile, I'm not sure whether you are able to get your mic on and maybe get your camera on, and whether you can come in now.
Can you hear and see me?
We can hear you, not see you yet. There we go, we can see you now.
Okay.
Brilliant. Hello. Thank you.
I have a very complex relationship with team. So let me start. I come into this conversation with two feelings. There are things that excite me about where we are, and there are things that sadden me, just like everyone else who is saddened by this state of violence. One of the things that really stand out for me as I come into this conversation, because I locate or place myself as a generation that was quite excited about the new constitution, that started working about 2 decades ago as feminists, as lawyers, and really believed in the transformative power of the law. And it was a very exciting and challenging time going to the Constitutional Court and seeing what was possible. Old laws that were discriminatory on the basis of gender being struck down. And that was a very happy moment, in our time. But what we have seen, just looking at these 2 cases, it's that where we are now, something has shifted. We've decentered courtrooms and legislature as the only site of legitimate struggles in the fight against gender-based violence, against women. So there is now a nuanced critique of the law in responding to gender-based violence against women. So after 2 decades of groundbreaking feminist jurisprudence from the Constitutional Court and other courts, we can now decisively say that trickle-down reform is a scam, just like trickle-down economics is. And we say this because we acknowledge that what we have been able to achieve in the courtrooms has really been different set of facts, but really asking the court a very similar question, whether the state does have a duty to protect us from violence. And we do know that they actually do have this duty to do that. The other thing that is shifting is that, during the Jacob Zuma rape trial, we had 1 in 9, but over the past 5 years, we have seen the emergence of a number of different formations to respond. We have Shugumisa that we saw in the gender bills, total shutdown that called us out to the street and said we are going to shut down this country. We've got call to action that's looking at the National Strategic Plan, and a number of other formations that are coming together and saying it's no longer, the men who are wearing black coats and saying the issues have gone legal now and everything else is surplus to requirement. We're having a conversation about how all hands on deck is what we need to do in order to be able to respond. So there has been an attempt to also build the feminist movement that's using the law to pay attention to the intersect between class, race, and other things that have made healthy collaborations not so possible in the past. So we operate in a context today that is far more different than what happened with legal feminists in the Jacob Zuma rape trial. So it's highly unlikely that you would have legal feminists going to court without the buying in of the broader movement or without that kind of conversation, taking place in the way that it did in 2005. The thing that's happening inside the courtroom though, so here we're dealing with a criminal trial and an appeal of a criminal trial. And the big distinctions or the shifts that we are seeing there, some of the things remain the same and some things are changing. We know that acquaintance or intimate partner rape remains very difficult for courts to actually get. Courts get stranger danger, rape. It's like this person just picked you up from somewhere and raped you. But there is this continuing relegation of intimate partner violence or acquaintance rape to the private sphere. We don't know what's going on, and the law does not know how to respond to this. And that's why most of us were in some ways happy that in the Togo case, the prosecutor prosecuted this case because in many instances, these are cases that do not go to court. So, but we continue to see the refusal to apply the Bill of Rights and move towards a victim-centered approach when it comes to this kind of case. Togo case is a typical example of a willful disregard of the Constitution, international human rights standards, and case law that has been developed. So this idea that the court's hands were tied, or most of the time, we have this problem that the problem is the legislature. So go and get the legislature to fix this problem because we are always going to find that there is this reasonable, belief, which the Constitution tells us that is actually unreasonable. The Zuma rape trial, what it did in the courtroom was to tell us that it doesn't matter how many changes we make. The person who's interpreting the law is the one who is actually making the decision on what is relevant and what's not relevant. So what we saw in the Jacob Zuma rape trial is when a diary that tells what happened to a young person who, in any reasonable thing, would constitute rape, being used against her as evidence of lying about past rapes. And of course, the question of what's relevant and how the court continues to treat relevance, this is after the Zuma rape trial happened, when the legislature and courts had said evidence of past sexual history is inadmissible. But we do know that the defense and the courts have a way of bringing it back, despite the changes that have happened in the law. But the Togo takes the dismissal of legal changes to another level. So this is where I'm going to focus before I close. You see, they deployed a trick. It centers the appeal on the accused person's right to fair trial. And this is something that's quite important to really get, because as feminists, we have been made to look like we really do not understand the law. We'd want people not to get bail. We have no respect for the right to fair trial. And so this case centers, his right to fair trial, that an accused person has got a right to a fair trial. The court overturns the conviction because the law gives him a defense of reasonable belief, and that the state has failed to prove that his belief that there was no consent was unreasonable. It does so by simply erasing her narrative, her experience, and make her invisible in her own trial. So it uses traditional criminal law understanding that tells us that in a criminal trial, there's a complainant who's the state, and the victim is a witness, in her own case. And she's not accorded really any protection. The victim is represented by the prosecutor, and whatever the prosecutor does is then attributed to the victim. So in this case, we don't have victims' rights advocates as it happens in other jurisdictions. And then the prosecutor says things that can be demeaning to both parties, the accused and the complainant, but the court finds that the accused person's rights is what has been violated. There is no finding that her right to dignity is violated by the comments that have been made by the prosecutor, because in this case, for example, she never held up her virginity as the thing that she wanted the court to protect, although the prosecutor goes on to make a big deal about it. We have the right to equality, and I think Kwezi alluded to this, but what we see is the co-option of women's rights gains. When the criminal justice system routinely fails sex workers by making it seem like they were not rapeable, capable of being raped, feminists argue that rape is rape and it does not matter who the victim is. In dismissing the relevance of her virginity, the court takes this principle and then turn it around, and say, we have no separate laws for virgins, but she never asked to be treated differently because of her virginity. Kwezi mentioned the power, patriarchy, and privilege, that the court says there are no extenuating circumstances that will constitute an imbalance of power, something that will make her unable to consent because they are both 23-year-old. And this is just using formal equality as if there is no context here. But if the court were to decide to use or to give her constitutional rights, we will have an analysis of reasonableness of the belief and where virginity is relevant, but not in the way that the court has decided it is not relevant. Someone who has been told that I do not wish to have penetrative sex at the beginning of the evening and proceeds to do exactly that is given a defense of tacit consent. The right to bodily autonomy, which is about when to have sex, who to have sex with, how to have sex, are completely displaced. When the autonomy is taken away from her and the court that's doing a constitutional analysis does not go anywhere near this right, because if she has this right, then it's obvious that when having sex with someone and someone who has made a decision to delay her sexual debut, you would want to ascertain whether the yes is now a yes and whether the no from the beginning still stands. But that's not what the court does, in this instance. When the court manufactures this get out of jail free card for him, the court takes us, to another route. It overlooks the right to equality, bodily autonomy, and the right to be free from violence. It actually does not stop there. It rearranges the sequence of the admission that happened at the lower court. And they said that when you made an admission, you did not admit to the proper sequence of events, because the court decides what's relevant is when you was given, not whether a yes was ever given at any point. So, in conclusion, it does matter who is there, interpreting the law. It does matter what it is that they choose to read from the Sexual Offences Act, from the Constitution, from international human rights standards. We are not going to spend the rest of our lives asking the legislature to change laws where there is willful disregard to apply the law that we have. And I will come back and deal with the other questions maybe when it arrives, but I'll stop here for now. Thank you.
Thank you, Sibongile. Thank you so much. Yes, right. So our last speaker then is Bronwyn Pithi, and she's an admitted advocate in the High Court of South Africa, working for the Women's Legal Centre since 2016. She leads the Right to Be Free from Violence program and is currently involved in several constitutional litigation cases challenging the constitutionality of legislation, implementation of judgments and laws, and access to justice for marginalized and vulnerable women. Prior to this, she was an advocate in the Sexual Offences and Community Affairs Unit of the NPA of South Africa. She was a member of the Minister of Justice and Constitutional Development's National Advisory Task Team on the re-establishment of the Sexual Offences Courts, and she was involved in the implementation and management of sexual offences courts nationally at the NPA, where she was responsible for the overall oversight and management of the prosecution of sexual offences in the Western Cape, including the management of the Thuthuzela care centres. And she's been intrinsically involved in the development and drafting of numerous pieces of legislation and policy regarding violence against women for the past 25 years. So over to Bronwyn, who's going to give us the last 10 minutes. Thank you.
Thanks very much. I'm just going to share my screen. I'm one of those people who likes to have things in front of me, if that's okay. I just hope that it loads. There we go. Could I just ask if everyone is seeing that?
Yes, we are seeing it. Thank you.
Okay, so if I just start there, you can just see the first slide. I'm sorry, it looks very odd on my side, so I'm just going to keep going. Okay, so first of all, thank you very much for the invitation to be here and to present to you. I'm hoping that quite a lot of what I will say will follow on nicely from what Sibongile has said, because really what I was trying to look at is a trajectory of what the courts have said and how they've acknowledged and how they have developed their jurisprudence, particularly around violence, and how, if at all, that has influenced the experiences of women in the criminal justice system. So my outline briefly is to look at those constitutional court jurisprudence aspects, and then actually look at the nature of the cases that have been before the Constitutional Court. The constitutional rights that both Sibongile and Kwezi alluded to, and then looking at the legislation. And then I wanted to look specifically just at a quick little kind of, I don't know what the best word to use would be, but a bit of a case study on the issue of the Zuma trial and what Mr. Malema said at the time and the issues that then went to the Equality Court. I want to look at attrition and the nature of cases that really impact on attrition, and then look specifically at whether we can consider any of these victories, and whether we're looking at, as Sibongile has looked at, to look at what the defences that were given to certainly Mr. Xoko in that case, and to some extent, although it wasn't as expressly said in the Zuma trial. So if I could go to the first one, I'm just put it up there. I'm not going to read everything because I think most of you are probably quite familiar with a lot of these cases. But I just wanted to show that as far back as 2001 in the Carmichael case, which is one of the most groundbreaking cases that we had in the Constitutional Court around the development of our common law. I won't go into the technical issues around it, but you can see there that the Constitutional Court recognizes sexual violence, and the threat of sexual violence is the single greatest threat to the self-determination of South African women. It goes to the very core of the subordination of women in society. Next case, 2007, Masia, that sexual violence and rape reflects the unequal power relationships between men and women in our society. The case of F, entrenches patriarchy and it imperils the freedom of self-determination of women. In Levenstein, there was an acknowledgement of some of the submissions that the Women's Legal Centre made, that very, very often around the ideas around sexual offences are imbued with outdated patriarchal's idea about the moral gravity and harmfulness of different sexual types of offences. The court more recently, in a very good judgment a couple of years ago, where I think some of my colleagues who are on this webinar now were involved as amici in that case, in the Chabalala and the Thuli cases, where you can see there again, there is an absolute acknowledgement by the Constitutional Court of the insidiousness and the destruction and the discrimination and the barrier to equality that violence against women poses to women in South Africa. And very specifically, there was an acknowledgement by one of the judges who looked at the intersectionality and how there was an acknowledgement that specifically Black women in South Africa are discriminated against on various levels. Again, I think a lot of this is not things that I need to point out to you, but what I'm really trying to show is that in the Constitutional Court, there has really been an acknowledgement that the punis, the desperate and horrific consequences of violence on women. But the big but is, when we look then at our constitutional rights, which Sibongile spoke about, specifically the right to dignity, to be free from violence, freedom of movement, body autonomy, which I didn't put in there, but which is an obvious one. And then we look specifically at the laws that we do have around the sexual offences legislation, which is broadly spoken about in terms of the SORMA, the new sexual offences legislation, which is now actually quite old. It was passed in 2007. And you can see there where the preamble really reflects and speaks to a lot of those constitutional rights. And very specifically, you'll see I've highlighted at the bottom, they will put in bold, afforded complainants of sexual offences the maximum and least traumatizing protection that the law can provide. So we have an excellent framework. And I think just to reflect on something that Sibo said just now is that feminists, in reacting to both the Zuma and the Xoko judgment, have been made out to not know the law. We don't understand the law. The response from a lot of academics and legal academics and practitioners were that basically this is what the law is in Xoko, where and again it's really relatively technical legal stuff, and I won't bore you with that, but really that it's a subjective test when we're talking about intention. And the bottom line is that you don't really understand the law, because if an accused honestly holds the belief that a complainant was consenting, then even if that belief is unreasonable, he must be found not guilty. And the issue really is that I think what Sibongile and I have been talking about and are hopefully going to have an opportunity to put before the Supreme Court of Appeal when this goes on appeal, which it is going on appeal, that we will be able to voice that no, actually what this really requires is a different interpretation of the law, and not just saying, well, that's the law. There is no doubt in my mind, obviously, that there are certain laws, be they statutory laws, all common law that simply can't be changed. It's like fitting a square into a round hole. It's simply not going to work. We do have to change some of the laws. But at the other end of the spectrum, there are plenty of laws that, if they are reinterpreted using a feminist lens, using a constitutional lens, can actually be interpreted in a way that gives it more meaning and a better depth to the meaning to the people it's meant to protect. So what I really wanted to look at very quickly was, some of you will have remembered that following the Zuma trial, Mr. Zuma announced at a political rally that when a woman didn't enjoy it, sex, she leaves the next morning. Those who had a nice time will wait until the sun comes out, request breakfast and taxi money. In the morning, that lady requested breakfast and taxi money. You don't ask for taxi money from somebody who raped you. Now, that was obviously referring to the complainants in the Zuma trial, and it was an absolute encapsulation, I think, to a large extent of what most people really believe. And when we looked at that, I wanted to look and show you what attrition looks like in this country, because although the Constitutional Court is saying all of these things about sexual offences and sexual violence, I believe that what the Constitutional Court is talking about are your stereotypical, conventional, mythical rapes. Not mythical in the sense that they don't work, they don't happen. Obviously, there are some horrific rapes that happen where there is a lot of violence, where people don't know each other, etc. But as soon as we get into the murky waters, so-called murky waters, of acquaintance rape, where people know each other, where there might be a previous sexual relationship, where there may be alcohol involved, suddenly all of those rules don't seem to apply. And suddenly we're not so sure that violence is such a terrible thing. And you'll see there from their attrition, the sexual violence, the very, very long bar is the number of cases that are reported. And everybody knows that cases are terribly underreported. The second little bar is the number of cases that actually find their way to trial. And the third bar is your conviction rate. I'm quickly going to show you what the NPA has been doing. There are over 50,000 rapes reported every year. They have been prosecuting fewer and fewer rapes over the last 7 years. You'll see in 2013, they were prosecuting just over 8,000 rapes. In the last 2020-2021 year, they were reporting just over, at least prosecuting just over 3,000. So of over 50,000 cases that are reported, in the last year, they only prosecuted they only prosecuted just over 3.5. And you'll see there that the difference between what the NPA says is their conviction rate and what the real conviction rate is fundamentally different, because the NPA works out their conviction rate in relation to the cases they take to court as opposed to the cases that are actually reported. And that the orange bars there show the cases reported. So basically, really what I'm saying is that these myths and stereotypes inform which cases are taken to trial, which cases actually make it to trial. And as Sibongile also referred, I was very, very surprised to actually even see a case like Xoko before the courts. The majority of cases of this nature with these types of facts simply don't, I'll wrap up right now, simply don't reflect the reality of women's lives. So really, when I'm talking about victories, I'm not so sure that we have taken the victories or the jurisprudence that has been developed is applying to the cases where the majority of women are, how the violence that is experienced by the majority of women in this country is being adequately reflected in our courts. And the issue of really taking a different interpretation of our common law is really how we should be approaching the situation, and not throwing everything out and saying that's just the way it is. Thanks.
Thank you very much, Bronwyn. Okay, we've had 5 really interesting presentations, a lot of themes that have come through, similar themes from our speakers. And I would just like to give each speaker, or the panel, not necessarily each person, but the panel, an opportunity to perhaps respond to each other before we open it up for questions. I'm also aware that the questions are often the really interesting parts of the discussion as well, and we don't have that much time left. So if I could ask the panelists to just briefly respond to each other, those who would like to. And I'm looking for the panelists to put up, to indicate yes. Orato, if you can go first. Thank you.
Thanks, everyone. I think in listening to everyone speak, I just wanted to kind of share something I was thinking about, which also informs like how I think about how we can respond to sexual violence broadly, which is like my research topic for my PhD. And Kwesi Lomso spoke about abolition and what that requires, which is one of the things I'm thinking about in my research. And when it comes to sexual violence, it is really difficult to speak about abolition, particularly prison abolition, because there's so much desperation for justice that to take away something that seems to deal with the problem, or to think about the problem without the police system and the legal systems as they exist, seems to take away safety rather than ensure it. One abolitionist thinker that I really am inspired by is Ruth Wilson Gilmore, who speaks about a lot of the ways that the prison industrial complex works in America, which I'll skip. But basically, in thinking about abolition, what she said is like, what is needed? And that question guides me a lot. And in thinking about, as I think Kwesi Lomso was speaking, what are the structural solutions that we can have to sexual violence and gender-based violence, understanding it as a structural problem? I think that something that is important to hold on to, despite all my pessimism, is the importance of harm reduction and also making sure that we protect the legal gains that we do have. And in this situation, I would like to refer to a case that the Women's Legal Center fought, I think, last year or this year, I'm not sure when it was, but it was recent, where someone had used the Domestic Violence Act and the Protection Against Harassment Act in order to have someone who'd accused them of rape be declared not allowed to speak about their rape to anyone. And the Women's Legal Center appealed this, and the article that I am adding to the chat is one where you can read more about it. And in the article, the authors speak about the importance of not making sure that the laws that we do have that have been so well designed to protect victims and survivors of violence do not get misappropriated. So I think in just summing up, my kind of response or orientation to the law, despite my disillusionment, isn't that we never think about it, but we kind of hold down all the forts at the same time. So holding down the forts would look like making sure that what has been fought for does not slip out of our reach and start being used against the people it was designed to protect, while we also think broadly about what is needed in terms of care and support for people who experience violence, and broadly what political education is needed in order to ensure that we have safe and healthy sexual relations across society.
Thank you, Horoto. There's some comments in the chat directed to things you've been saying, but before we move there, I would just want to check with the other speakers whether anybody would like to come in and respond to what's been said on the panel. Kwesi Loma, Shireen, Sibongile, Bronwyn.
I think it would be good to hear from other people.
Okay. Yeah, right. Thanks, Shireen. Okay. Bronwyn, I'm not seeing your screen anymore, so I don't think it's being shared. Right, so let's open up then for any questions, any comments. And I'm seeing that in the chat there's a question about feminist abolitionist literature from the Global South. I don't know if anybody is able to comment or maybe put something into the chat about that. I see there's a new message. Thank you. I think that's a response. I'm not seeing any hands. If anybody notices hands, then please let me know. Okay, Simongela, it's over to you. Thank you.
Thank you, everyone. Thank you for such amazing and rich contributions. My question can be answered by Bronwyn or Sibongile. For us who are not lawyers or have limited information on how, legal processes work, can you kindly take us through the appeals process and how it will work in relation to the Xoko judgment?
Thanks. Who would like to come through? Bronwyn? I see your screen.
Yeah, I'm happy to, and then obviously, Sibu can add to it. Basically, the process is that the state may only appeal against a matter on a point of law and not on a point of fact. And initially, there was quite a lot of dispute as to whether there really was a question of law in the Xoko case or whether it was just a factual finding that was not agreed with. But the NPA have officially appealed it on points of law. And what happens now is that organizations who would like to, or individuals, interest groups who would like to intervene as friends of the court or amicus curiae will then make application to the Supreme Court of Appeal. So it will go to the Supreme Court of Appeal. Some of us will apply. The Women's Legal Center is, as far as I understand, ISLA is, but obviously Isibo will speak for herself, that we will try to come in and bring the perspectives that we're talking about. It depends on whether the SCA will let us in. It's not a foregone conclusion that they will admit us as amici. But I have very little doubt that this matter will probably eventually find its way into the Constitutional Court. And I think that's really where we will have a really good ventilation of the issues. Although I think that the SCA will need to give some guidance as to the proper interpretation of the law. Sibu, I don't know if you want to add to that, if that kind of covers the appeal process. Thanks.
Sibongile? Thank you.
So what we have said is that what happens inside the court, what happens outside of the courtroom is just as important as what happens inside the courtroom. So what we did after finding out about the Xoko decision in October, a number of civil society organizations came together in order to think about what comprehensive response could look like. And so we have groups that are working, feminist academics that are working with the survivor and other organizations providing psychosocial support, research, communications, and then the legal organizations working on filing the amicus, but also with the other organizations that do other services who can come in and join as amici at the Supreme Court of Appeal. And I'm mentioning this as part of the lessons I think that we have learned, that lawyers cannot be going kind of to court by themselves, and that there is also a lot of work that's about shifting the public narrative on how we understand rape, and advocacy that's really about talking about what does consent mean in rape cases outside of the courtroom.
Thank you very much. And I think your last sentence pulls together some of the main themes. One is the need for struggle around law, as well as the need for dealing with the law. And I think that comes together. So I'm seeing that Yvette Abrahams, over to you.
Hi, thank you. Thank you, Amanda and Simamkile, for organizing this very important get together. I think it's really great. And Shireen, particularly that you gave the young people a sense of history. But one thing that's often forgotten about apartheid is, you know, we often talk about how racist it is, but how deeply sexist it was, and you know, particularly intersectionally, how that got for Black women. But it's important, if the question we're asking is how far have we come, it's always important to have a baseline. Sibongile, lovely to see you 2 days running. I did want to say, though, that when we measure the gains of the Zuma rape case, surely one of the most important ones needs to be the Sexual Offences Act of 2007. If you recall, at the time of the trial, the previous act, which I believe was 1950s, an apartheid act on rape was still in force, and this despite the fact, Bronwyn will remind us, that the new Sexual Offences Act, I think, was one of the earliest demands made by the women's movement. I think it was just after the new constitution in 97 when we began to demand amendments to the rape law. And what really made it change was the Zuma trial itself. It was one of the last trials in South Africa when the victim's character was allowed to be placed on trial, because that was one of the things we'd specifically asked for, and that was specifically promulgated in the Sexual Offences Act of 2007. So I wanted to mention this, I think, particularly to give the young people a sense of perspective. I think when we look at the gains from the Zuma rape trial, they're not least, I would want to think, was the Fees Must Fall movement and the range of civil activism that our outrage gave rise to. But I did want to mention that, and specifically mention the work of the ANC Women's League, because I was at the CG myself in 2007 and witnessed the passing of the act, and it comes down to strategy. To get a new act passed, you need 155 MPs to pass it, to say yes. In 2005 or 6 or 7, you simply could not do that without the ANC Women's League. Whatever piece of legislation we were trying to advocate for, our first stop would be the ANCWL, because how else are you going to get 155 MPs to vote for? And so I do want to recognize that as one of their forgotten victories. Yes, they may have demonstrated outside the courtroom, but the work that they did behind the scenes to not just the Sexual Offences Act, but a number of important acts during that period, 2007 to 2011, when I left the CG, I do want to give them that acknowledgement, because justice is due to justice should be served with justice is due. Thank you.
Thank you, Yvette. Thank you. Bronwyn, over to you.
So, and I just wanted to thank Yvette for raising that, because I think it is a very significant thing. I think one of the sad things is, though, that if we look at the trajectory of the changes in legislation and the acknowledgement of moving from the common law, which was very restrictive and extraordinary patriarchal, to a more kind of equality-based piece of legislation in our Sexual Offences Act now, unfortunately, we're still not seeing access to justice. We're not seeing women still accessing the criminal justice system through this piece of legislation. And that's what worries me, is that I think we do have a good piece of legislation. I think we have done good amendments. We've got excellent laws. But my problem is that probably 90% of our sexual offences cases are heard in our lower courts, in our regional courts. And there, we're not seeing enough of the constitutional jurisprudence. We're not seeing enough of a proper interpretation of the law. And we've seen it in Xoko now as well. Ironically, it was the regional court who I actually think gave a better judgment, although there were some problems with it, than the High Court judgment. So absolutely, the legislation is important. Good law is vital. What I'm worried about is still the decisions that are being made by the decision makers are still very informed by all of the patriarchal, mythical, stereotype notions that go with the law. So unfortunately, I think it's a bit of both. Thanks.
Thank you, Bronwyn. Okay, there was a hand up. Yes. Ms. Stevens, over to you.
Hi, Thank you very much. I'm curious about the context of health in relation to the jurisprudence and discussion today. In the Zuma trial, I was absolutely flabbergasted and taken aback when there was very little engagement with the kind of conversation that Zuma had, where he basically asked Kwesi if she was on protection or taking protection. And I wondered why this wasn't taken up further. And it kind of relates to, I want to kind of link it to Kwesi Lomso's discussion or ideas about rape being bad sex. It's almost like the health factors from mental health to contraception to the possibility of becoming pregnant and the consequences thereof. How does that, where is that all leading to? Why is there kind of almost a kind of verticalization and not actually addressing these soliloquy in the kind of court's questioning? I'm just a bit kind of taken aback, and it's really interesting, I think, because of the kind, the lenses of patriarchal law. What, the fact still is that I think why Zuma was able to ask that was the assumption was that she was taking Depo-Provera, which is what 60% of contraceptives dispensed in South Africa is still Depo-Provera. It's a really bad health option. So thank you.
Thank you. Would any of the panelists like to address that? You can just put on your mic and respond. Okay. All right, so well, thank you for that comment.
Maybe, I think mine is an almost lazy answer. Well, not necessarily, which is to reiterate the point I was making earlier, that of course the instrument that we have by way of the court is not the kind of, and will never be, the place where we receive like justice, right? And that we kind of, even strategically, we need to be very clear what it is that we are doing through legal processes and what needs to be built elsewhere, parallel. And of course, in my dream world, to then completely, overthrow the punishment space. But even as it sits, the kind of nuance we're talking about how harm happens, how violence happens, cannot be fully encompassed through those processes. So this is why it's important for us to have, and as feminists have had throughout generations, right? Multiple strategies, multiple sites of struggle, multiple sites of, redress, repair, justice.
Thank you. Shireen?
Thanks. I just, on the issues of health and mental health, it's what I was thinking laterally from that, Marion, to the way in which the responses to the issue of consent. Sorry, I'm feeling suddenly feeling very COVID-y my brain is. The thing I wanted to say was that it was striking how many ordinary women who were interviewed during those protests outside the court and on the street thought that the idea of women having any sexuality or having any right to consent was an odd one. You know, that they thought that that it was completely that Zuma showed care when he asked that. That he, you know, clearly was concerned about her not being pregnant, and therefore it was all consensual. And there was so much kind of disbelief that this could be a violent and unwanted act.
Thank you, Shireen. Yes. In the chat, there's a number of comments from Sammy. I don't know if you want to come in and just talk to or pick up on one of your comments. You're asking about the Jaco Swart matter, and you're also asking about the NPA not having done enough. You just want to pick up some of the main points for the panel on your questions. Okay. Perhaps the panel anybody on the panel might like to comment on the Jaco Swart matter, where the NPA at first refused to prosecute Moreso, the judgment that was delivered afterwards. I'm just reading from the question.
Maybe I'll give a brief comment on that. I don't know that much, and I actually haven't seen the judgment. But my understanding is that it was obviously, I think that the issue, for those of you who don't know what it's about, was a domestic violence or an assault matter, where a man was charged with assault with intent to do grievous bodily harm against his partner, and there was video evidence of it. And he has been given a suspended sentence and 20,000 Rand fine. And I think a lot of people are very unhappy about that. I don't know the history of it in terms of when the NPA initially decided or declined to prosecute, but just in terms of picking up on a theme around that, one of the things that we're seeing and what we're building a case on at the moment is the decisions by the NPA not to prosecute both sexual and domestic violence matters, and what it is and what is informing that decision making, which I alluded to at the end of when I was speaking. And really, we believe that those decisions are very, very much influenced by stereotypical beliefs, although everybody knows these days what to say and what not to say. And that's what worries me about the training. I think there was a question that was directed to me in the chat box around where the training would make a difference. My issue is that you can train people until you're blue in the face. It depends on who's doing the training and what the training content is. And at the moment, the police and the prosecution and judicial officers all go through a lot of training. Yet those of you who've done research on judgments and looked at judgments can see again and again all of those beliefs coming out very, very strongly. So my question is, who's doing the training and what is the content of the training? If it's in-house training, all you're doing is self-perpetuating the beliefs that exist in the institution anyway. These institutions are by definition and by culture incredibly conservative. And anyone who thinks out of the box simply, doesn't fit in very well. And I think that's really the problem that sits even with prosecutors who want to pursue cases that are difficult, will be dissuaded from doing so because of the incredible incentives around prosecution, conviction rates. And the best way you get a good conviction rate is to prosecute the easiest cases. So my biggest concern is, we could try and change the law, we could try and change our legislation, we can do all of that until we're blue in the face. But until we have the people who are implementing, really having a deeper understanding of what the nature, extent, the true understanding of violence and discrepancies of power, it's not going to make any real difference. So it's maybe a little bit of a cynical answer, but I really believe that that's where it lies. That's our biggest problem at the moment. Thanks.
Thank you. Yes, I was just going to come to that question in the chat box. So thank you, Bronwyn, for picking it up. And I think that Ms. Walker had her hand up earlier, and I think perhaps it was to draw attention to that question. We are over time, so I would like to thank the panel, but before we end, give everybody on the panel just an opportunity to make one or two closing remarks. Perhaps we could start with Sibongile. Oh, there we go. Your camera's on, Rota, so maybe you want to start with a closing remark or two. Thank you.
Okay. I think my closing remark would just be that I invite everyone who's interested in thinking through what abolition might look like and what, what's the word? Multifaceted responses to gender-based violence and sexual violence that don't involve the police to contact me and imagine it with me, because it's something that I feel really optimistic about, and I want to end on that optimistic note because I do have some optimism left in me despite all of the things that we've, as discussed, have been disappointing. But the abolitionist streak in me is really a sight that I think offers us a lot of hope in the ways in which we can reimagine a future that we want to actually exist in. And thank you for joining.
Thank you very much. Thank you. Sibongile, can I ask you for some closing remarks?
Yes. Building on a point that Shireen made in her closing, that it's not the law but that when we think about the law with something else, some of the things that we would need to do, that we kind of remember that the expectations that we have put on the criminal justice system as a country, not as people working on violence, as this last line of defense when the executive has failed, when all the other kind of public institutions continue to fail us, or legislature, and then kind of using football language, that they become this last line of defense, is a lot for any kind of judiciary to have to deal with. So this idea that high courts also will fail us, or Supreme Court will fail us, and we put all of this trust in the Constitutional Court, it's a lot. So I'd like us to go back and kind of buy in, like an invitation to buy into this National Strategic Plan on Gender-Based Violence and Femicide, and the broadening of the things that would need to happen, that we are not only looking at criminal justice as this response that we need from the state, but that we start working on prevention or rebuilding social cohesion, all those 6 pillars that are in the National Strategic Plan, because the answer may lie somewhere there in ensuring that we don't just have to call the police.
Thank you very much. And thank you for that invitation. Shireen, would you like to say anything?
Well, all I would add is that, ultimately we have to be talking about the relations between us, between all of us who live in society and communities, and that we do need to address questions of violence in a much broader way. We need to, regard in none of these mechanisms, all of these mechanisms are kind of a way of regulating that in a context of huge inequalities. But what we really want to aim for us is a society in which we are treating each other differently, and which we are able to feel safe and free. And so that is a conversation that goes way beyond the law. And sometimes even bad law and bad judgments, as in the Zuma case, open up a possibility for us to put those questions on the table. But what's been absolutely central in the last periods between the two judgments has been the rise of ordinary voices, movements from below, people speaking out about what is acceptable and not acceptable in all kinds of contexts, not just in the context of heterosexual relationships. So, the questions of the social, the questions of care for each other and respect for each other and so on, are where we also have to push, so that we don't have a situation in which judges can get away with saying that rape, when it takes place in a family context, is not so bad because that is a form of love. Because we've articulated other radical notions of love and care and equality.
Thank you, Shireen. Thank you. Kwesi Lomso, do you want to?
Thank you so much for a really great conversation, and I think I want to build on what Usibongile had said, where I think the last line you used was that we don't just have to call the police, and to say that we don't, right? Majority of us don't necessarily and don't call the police in terms of when something happens or when we are faced with crises. And for me, then it's about saying, how are we and how should we be learning? So I'm accepting both invitations from Sibongile and Okurata. How are we learning from how we are building communities, how we're building families, how we are dealing with these things? What are the strategies that exist and need to be lifted? What are the strategies that need to be built? And what is the kind of multiplicity of things that we can plug into to try and build safer and communities where we can all thrive? So for me, and I have hope because Black people and feminists have always done this for society, where we get told that this is the law and the law is the law, or this is what this is, and they've opened up our imaginative capacities to then say what else, because we want more. And so with all of that, I'm a little bit hopeful still. Thank you.
Thank you very much. Thank you. And Bronwyn, do you have?
Yeah, just very briefly, I really don't think I can add much more to what everybody else has said, other than to say that I think that I fully recognize the limitations of the law. I think it does have a very rightful place to provide justice in the true sense, but that it is very limited in many ways, and it depends who controls it. And I think everyone is right that there are other sites of struggle that can be as effective, if not more effective. But I guess we should also hold on to the law, because we do live in a country, a constitutional democracy, where the rule of law is essential, and we have to uphold that as best possible, but hopefully with a bit of a more feminist interpretation of it. Thanks.
Thank you, Bronwyn, and thank you to the panelists, and thank you to the participants for giving us a really interesting and important session. I think so many important things have been said today. There's been so many themes that are interesting and cross-cutting, and the topic was gains and setbacks. But I think for me, what I've learned is that from the setbacks we have seen gains. and it's important. We've seen the building of movements, we've seen creation of unity, and we need to work on two fronts. The law, the institution, the organizations have to transform, and this involves struggle from inside and outside. Thank you very much to everybody for your participation.